Maybe.
My Lord, may I make two further points about the plain language of the section and deal with matters that were raised this morning. First of all, the respondent does submit that the word display and the word wears and carries do connote a state of mind, and that's deliberation. So all of those activities for the purposes of this section cannot be committed inadvertently. And that does deal with the submission, at least in part, that certain what are described as absurd consequences may arise without a mental element. The second point, it relates to what facts are placed in the mind of the reasonable bystander. The respondent submits that the only matters which found or may found the reasonable suspicion or a consideration of that are those factors which are observable. It is, in the language of the section, the way or the circumstances in which the matter is displayed or worn or carried. And of course, this is a piece of legislation relating to a public display. And so the suspicion is to arise, if it's to arise at all, from what is observed, publicly observable by someone watching the display of the article in this case. And so what is not imported into the mind of the reasonable bystander, and what does not fall within the words in such a way or in such circumstances, are unknowable personal characteristics of the accused. For example, the fact that he cannot speak English, unless that is something which is observable in the public display.
How then do you deal with the hypothetical that was given to us right at the start of the person who can't read English, who picks up a placard not knowing what's on the placard? What do you say to that?
If it was observable that the person did not speak English and that was part of the observable circumstances, then plainly that would be a relevant factor. If, however, that wasn't observable, then the person would commit the offence.
And the same for the blind person?
The same.
Depends whether it's, you're saying, reasonably observable.
Yes.
Yeah.
May I then move on to a number of other factors that indicate that the respondent's construction is correct? I might perhaps deal with these in bullet point form, and I've already mentioned some of them. The third factor on which the respondent relies is the fact that there is good reason why Parliament would have legislated in this way, namely to achieve the aim of starving terrorist organisations of favourable publicity and public displays of strength that might otherwise encourage support. And that is not a speculative assertion on the part of the respondent. That is self-evidently the mischief at which the section is aimed.
Could it also have been aimed at the opposite effect? That it might incite someone observing this display of loyalty to a proscribed organisation to react badly to it, and that would have public order consequences?
Does my Lord mean that as it were, someone from an opposing...
From an opposing camp, yes.
Exactly. And because, of course, there is a public order aspect to this. And so whatever is happening, whatever is prohibited, is happening in public and is observable. And so there is always the possibility that conflict may arise because by their nature, these proscribed organisations are, to say the least, highly controversial and are the subject of fierce opposition. So that is inherent. But the fourth factor on which the respondent relies is the setting of Section 13 within the scheme of Part 2 offences. And the appellant's interpretation is inconsistent with its place in that scheme. And this is the point it's really a twofold point. First of all, that the appellant's construction would elide Section 13 with Section 12 in large measure. And secondly, it doesn't explain the vast disparity in penalty. And the respondent submits that the only explanation for that matter is that Section 13 is dealing with a very different set of facts and circumstances. The fifth factor is that the other offence-creating provisions of the Act, where a mental element is required, make express provision for that. And the respondent accepts, of course, that that is not necessarily a conclusive matter, but it is a relevant factor. That's the position throughout the Act, but it's also the position specifically in Part 2, where Section 12, subsection 2, expressly provides for the requirement of proof of knowledge. A person commits an offence if he arranges, etc., a meeting which he knows is A, B, and C.
12.2. Yes.
So that's at 299.
Yes.
Subsection 2, which is the now the third offence in Section 12. There's an express requirement in relation to his state of mind, the accused state of mind. It's also the case that in the amendment in subsection 1A, the question of recklessness was inserted or provided for in that new offence. So Parliament took the trouble to make express provision. At the same time that that was inserted in Section 12, Parliament also inserted subsection 1A in Section 13, at 301, which is a mirror offence to subsection 1 in the case of publishing. But again, in doing that, Parliament did not make any provision, as it had made in Section 12(1)(a), for the requirement of recklessness or any other state of mind.
Were those two subsections introduced at the same time?
They were. So that the respondent submits that that is, whilst not being conclusive, it is a strong indicator of the position. There is one other point in relation to Section 12, and it relates to the offence contrary to Section 12(2)(c), which is where a person commits an offence if he arranges a meeting which he knows is to be addressed by a person who belongs or professes to belong to a prescribed organisation. That offence, 2C, is subject to a statutory defence, which is at subsection 4. And the defence is made out if the accused did not have, or proves that he did not have, a particular state of mind. And there are 2 points here. One is, of course, the offences in Section 13 do not have such a defence. But even in Section 12, this defence only applies where the meeting in question was a private meeting, where a person is charged with an offence under subsection 2C in respect of a private meeting. So even if the meeting is in public and the accused does not have a relevant state of mind, he commits the offence. And so the scheme of the Act in Part 2 in these offences does appear to draw a distinction between acts that take place in public on the one hand and that take place in private on the other. Everything in relation to Section 13 is an act that takes place in public. There are of course, many other sections within the 2000 Act where offences make specific provision for various states of mind. And the appellant's argument in relation to this, set out in writing, is that the Act is a consolidating piece of legislation, and it's not correct to say that it is a coherent scheme. There are just a collection of diverse provisions. Well, the respondent doesn't accept that, but in particular doesn't accept that Part 2 offences looked at together can be regarded as disparate offences. It's quite apparent from the way they are structured together. But they are a coherent set of offences designed to enforce the first part of Part 2, by which organisations are proscribed.
And am I right in thinking that subject to 12(1)(a) and 13(1)(a), they were all introduced at the same time in the original provisions of the Terrorism Act 2000?
They were, and the only additional amendment was to the penalty.
Yes.
Was for sections 11 and 12, which was 10 years, is now 14 years.
Can I just check one point with you? You've given us some provisions where there are express words importing a mens rea. When you look at section 11(1), and similarly 12(1), is your argument that they are offences that impliedly require a mens rea because the words belongs or professes to belong to can't be done without mens rea? And similarly, is that the same point about inviting support?
Exactly. And that's what the Court of Appeal found in Chowdhury in relation to inviting support. And belongs and professes, the respondent would submit, would be classic examples of physical acts which connote a state of mind.
Yes, but would you say that there is a state of mind in relation to the organisation being proscribed? I mean, one has to know that you're joining or belonging to an organisation, but you may not know it's prescribed.
Exactly so. Similar to possession, the way that a possession of an item is viewed in the criminal law. Possession is a physical act that connotes you know that you are in possession of an item. What that item is not something that you need to know in order to possess it, but you need to know that you have the item. And the respondent would say it's the same here. You can't profess something accidentally or inadvertently. You must deliberately or intentionally profess something, but you don't need to know that it is prescribed. The same in section 13. You need to deliberately display, an accused would need to deliberately display the article, but that imported mental element does not extend to the fact of the article being connected to a prescribed organisation. That's the way the respondent would put it. The sixth factor is a short point. It's the legislative history. There's nothing in the legislative history to indicate that there is a mental element in section 13. The written submissions deal with the provision dating back to the Prevention of Terrorism Act and also mirrored in the Emergency Provision Act in respect of Northern Ireland. It's right to say that it may have its roots back in the 1936 Public Order Act, with which the case of O'Moran was concerned with, but the fact of the matter is O'Moran was concerned with a different offence. The wording was not the same. It hasn't been simply transposed into the current legislation. That came in the 1970s with the Prevention of Terrorism Act, and in essence, the wording has remained the same since. The seventh factor, I've already really referred to, it's the amendment, and this was the amendment to section 12 and 13 that was dealt with by the Divisional Court. The eighth factor is that, for the reasons I've explained, the respondent doesn't accept that there would be absurd or arbitrary consequences. And the ninth factor is that if an intention of the kind for which the appellants contend was required in section 13, or I would add that the offence could only be committed if it was proximate or gave rise to a real risk of imminent violence, both of those matters would presumably, on the appellant's case, have an impact on section 11 and section 12 offences, and therefore it would not be an offence for a person to profess membership of a proscribed organisation unless that profession gave rise to an immediate risk. And the respondent doesn't accept that.
When you say you don't accept absurd or arbitrary consequences, some people might say that it is absurd or arbitrary for a blind person carrying a flag, they don't know what's on the flag, or for somebody who can't read English to be carrying a placard that they can't read, to be guilty of this offence. Why do you say that's not absurd or arbitrary?
I'd make the following points. First of all, that hypothetical example ought not to lead to the conclusion that it must be remedied by importing a mental element. But the points I'd make are these. First of all, obviously those were not the facts of this case. Secondly, the need for deliberation in respect of the display in the first place, and also the observable circumstances, would in many cases deal with any potentially absurd or arbitrary positions that may arise. Thirdly, whilst the example is given, it's been postulated by the court and by my learned friend, as far as we're aware, the criminal law is not replete with any examples of this in practice. And fourthly, there is also it's also relevant to note the availability of prosecutorial discretion. Now, I accept that that is not an answer in the sense that it cannot place an arbitrary threshold or bar to when an offence is committed and when it's not committed. However, it is a relevant factor, and if it was the case, in any particular case, that someone was suffering from a physical or mental disability that had a bearing on their conduct, or there was something else that was exceptional in relation to a particular case, that is a factor that a prosecutor could take into account when determining whether or not to bring a charge. And so there are a range of factors that the respondent would draw to the court's attention and make submissions on in this regard that would lead to the conclusion that these kinds of hypothetical examples are unlikely to arise in practice and don't of themselves lead to the conclusion that Parliament must have intended knowledge or intent. So that's the way that the respondent...
And if a person is too drunk to know what they're doing, that's not usually a defence, is it?
Not when intention is an ingredient of the offence.
So that wouldn't help anyway. But in this case, if there is no mens rea, it's not going to stop the person being convicted.
It's not going to stop the person being convicted, unless, of course, they were observably very drunk, and it would have been apparent to a reasonable bystander that they didn't know what was on the flag, and they picked it up to wrap it around them to keep warm, or an infinite number of varieties of that. But if the observable circumstances give rise to the conclusion that the person is not a supporter of the prescribed organisation, then of course he would be found not guilty.
I mean, that's odd because he may still have given publicity to the organisation by his activity, but the offence is more narrowly confined.
It is. It is. It's an offence, really, in terms of what's observable, of giving the impression of a show of support, public show of support. May I then move on to the position under Article 10? Perhaps I should say something about legality at the outset, because the respondent had understood that legality fell within the Article 10 framework in terms of the appellant submissions. But can I, whether that's the case or not, can I just make the following bullet points in relation to it? The test of foreseeability has been cited from the case of Gallagher this morning by my learned friend. But the point that the respondent makes is that, as was shown to the court in the case of Mohammed by my learned friend, this aspect of legal certainty concerns legal certainty, not necessarily or not at all factual certainty. And this was the point made by the divisional court at paragraph 63 of the judgment, at page 147. The respondent submits that the offence is legally certain, the provisions are clear. Whether a person in fact commits the offence will of course depend on the facts and an assessment of the facts. That is inevitable in any case, but it does not make the offence unforeseeable or uncertain. The logic of the appellant's argument on this point is that any offence committed without a mental element prevents a citizen from regulating their conduct to avoid conviction, and as such the interference with that conduct will fail a test of foreseeability. But the respondent simply observes that there's no basis in logic or in authority for reaching that conclusion, and the position here is that anyone should know and anyone could know that if they wave the flag of a terrorist organisation which has been prescribed, they are liable to prosecution, conviction and punishment. And therefore they are able to regulate their conduct accordingly. On the question of proportionality, the appellants...
Are you moving to Article 10 proper now?
Article 10 proper, yes. The appellants are contending not that Article 10 gives rise to the conclusion that a mental element ought to be imported into the offence, as I understand it, but that Article 10 prohibits an interference with expression unless that expression gives rise to the risk of violence. The submission of the respondent is that that proposition or that threshold is simply not found in the case law. The relevant high-level principles are found in the case of Zana, and can I take my lord to page 538? And in particular within Zana at 560. The Roman sections 1, 2 and 3 are repeated in most of the cases that have been cited before the court. But in summary, the starting point is that freedom of expression is one of the essential foundations of a democratic society, is subject to exceptions which are to be strictly construed, and the need for exceptions must be convincingly established. That's point 1. Point 2, the requirement that a restriction is necessary implies the existence of a pressing social need. And 3, on the question of proportionality, that question must be considered in light of a case as a whole, including the content and context of the expression in question. And in relation to the application of those high-level principles to the point made by the appellant, may I make the following points? First, the starting point in any assessment of Section 13 is to recognise the legitimate aim at which it is directed, which is self-evident and yet important. The aim is the suppression of terrorism and the protection of the life and property of citizens. And its aim is the suppression of terrorism at its root, before violence is risked, let alone before violence takes place. And the respondent submits that as a matter of principle, Article 10 does not mean, or should not be interpreted to mean, that the criminal law may not take steps to suppress terrorism at root by stifling its support and preventing it from having the air of publicity. The fight against terrorism, of course, is a matter which the Strasbourg Court recognises in its assessment of Article 10. And there are numerous references to that, without turning it up. The case of Arslan at electronic page 1399 is simply one example where the court notes the problems, the particular problems that are faced in the prevention of terrorism. But the legitimate aim is obvious and important. Secondly, the case law does not give rise to a rule that interference is only permissible where there is a real risk of violence associated with the expression. That is an argument that was rejected by the Divisional Court in Chowdhury. See paragraphs 61 to 89 of the judgment, which is at page 474 to 80, where Lady Justice Sharp considered the array of cases that had been cited and concluded that there was no bright line saying that such interference was only permissible in those circumstances. The contrary position is in fact the case. It is certainly true that whether expression incites violence is a factor to be taken into account, and it may be, in a particular case, a very important factor. But it is only a factor. And to make good that proposition, I hope in an expeditious way, may I take the court to just one section of the case of Arslan, which is at 1399. The case begins at 1377, but the particular feature is at 1399. Where the paragraph 46, the court begins by noting that there's little scope under Article 10.2 for restrictions on political speech or debate on questions of public interest, and I'll say something about that in a moment. But at the bottom of that paragraph, the court makes the point that where remarks incite to violence against an individual or a public official or a sector of the population, the state authorities enjoy a wider margin of appreciation when examining the need for an interference with a freedom of expression. So the point that's being made is, of course, that may be a very important factor, and it may make the margin of appreciation wider. However, that is not the only factor, still less is it some kind of threshold test. The case of Gull to which my learned friend referred was described by the Divisional Court as the high point of this argument. It was a case which concerned convictions for assisting an illegal organisation by shouting slogans at a public demonstration. The point being, on the Prosecutions case, that the slogans advocated violence, injury or harm to other persons, at least if taken literally. And so it was inevitable that the Strasbourg court, when analysing that, had to analyse whether they did in fact advocate violence, injury or harm in that way. So the observations that the court made in relation to that were in the context of a factual evaluation. And the point that the court made, and which the court was taken to this morning, is that what was being shouted were, as it were, hackneyed, well-known leftist slogans that in reality were not an incitement to violence. And that is evident at page 455. At paragraph 41 and 42 of the judgment. And so it cannot be said, the respondent submits, either that Gull provides authoritative support for the proposition that the incitement of violence or the risk of violence is a precondition for Section 10.2 interference in this area, and nor can it be said that on the facts it is indicative of what view should be reached in the present case.
Did you say paragraphs 42 to 44? Was that where?
41 to 42
right.
of the judgment. It was also noteworthy in that case that the applicants had been sentenced to 3 years and 9 months imprisonment. It was a very significant sentence. In the present case, the sentences were 2 conditional discharges and an absolute discharge. And the decisions in Strasbourg always look at the sentence on the facts, not the available sentence, but the sentence on the facts. And where sentences of more than 12 months imprisonment have been imposed, that's normally something that Strasbourg has something to say about. Factually, it was very different. Now, Gull fell one side of the line, but within paragraph 43 of Gull, there is reference to another case, Tazdemir in Turkey, which is in the court's authorities at 1794. It's a short judgment, and in essence, it's a not dissimilar case where the applicant had been convicted of a similar offence for shouting, in effect, words in effect, or up the PKK, long live the PKK. That was felt to fall the other side of the line, because it was an apology, as the court held it to be, an apology for terrorism, an apology for violence. And so there will always be cases that fall one side of the line or the other, but none of these cases, Gull or any other, is authoritative in relation to the facts of this case. My thirdly, make a general observation about the authorities in this area, which were cited, have been cited before this court and were dealt with by Lady Justice Sharp in Chowdhury. In the vast majority of them, they contain one of a number of characteristics absent from the present case, which make it readily identifiable and understandable why violations were found. And those characteristics relate to the means by which the expression was made and therefore the context of the words or expression themselves. And the means are predominantly journalistic expression, academic expression, or genuine political expression within the context of pluralistic debate, or artistic expression. So Erdogan, for example, which is at page 1463, I don't propose to take the court to these, I'll just make these bullet point submissions, was a journalistic article looking at the PKK from a sociological viewpoint. There was also a disproportionate sentence in that case. Karatas, 1597, was an anthology of poems, and the court held that words expressed in poems are to be, or are likely to be viewed in a different way than words expressed on the street. Baskaya at 1405 involved academic works in relation to the history of Turkey.
But isn't this finding the absence of an intent to incite? That's what the court's struggling to find in all of these.
Yes, but it's also looking at the effect of the words derived from the means by which they have been expressed. And what for example, in Baskaya, what the court also relied on in terms of this academic article, what it also considered was the public's right to be informed of these matters at the level of intellectual debate. So the courts were saying that these were legitimate. This was legitimate discussion, legitimate public consideration, and the same was true in Surek number 2 at 1738, where although it was a journalistic article, and although the interviewee was one of the PKK's leaders, there had been no incitement, and what was being discussed was political, and the public had a right to consider these underlying political and social matters.
Is that one of the cases we've got?
Yes, it's at 1738.
Thank you.
And the same point in TAS at 1787, another academic article. And so what the court was examining in all these cases were matters it regarded as contestable, legitimate subjects of pluralistic debate. But the fourth point that the respondent makes is that is in contrast to the position here. Section 13 does not in any way inhibit the expression of legitimate political debate, even of a shocking or offensive kind. It cannot be said that expression which arouses an objective suspicion of support for a terrorist organisation is legitimate in a democratic and pluralistic society. The fifth point that the respondent makes is that given that what is being prescribed, what is being prohibited is an act that gives rise to suspicion of support for a terrorist organisation, in an Article 10 context, it cannot be said to be unreasonable to prohibit such conduct. It's not unreasonable in an Article 10 or a terrorist context to expect individuals to regulate their conduct and expression to ensure that they do not arouse that suspicion, even inadvertently, that they are supporting terrorism. And it's not unreasonable to place the onus on an individual who is carrying a flag to ensure that he or she is not carrying a terrorist flag that will have a public impact. The sixth point that the respondent makes is the accepting that this is a terrorist offence and accepting that there is a stigma attached to it. Nevertheless, the sentence is not of the order of the offences that the Strasbourg court considered in the other cases. It is a low sentence and the offence is prosecutable only summarily. And the seventh and final point is that the limitation on expression is itself limited to organisations that are proscribed. The prescription underpins this interference. That is the starting point. It is only organisations that are terrorist organisations within the meaning of domestic legislation, and there is a pressing social need to inhibit conduct associated with it, short of incitement of violence and short of risking violence. So this is not a section that is directed at violence or terrorism, entities or expression, which is in any way abstract, contestable or arbitrary. Prescription that justifies the interference, but it also limits it. The appellant's argument is in effect that Article 10 permits people to carry flags of proscribed organisations in a supportive gesture, as long as at the time of doing so, there is no real risk of imminent violence. And the respondent simply doesn't accept that Article 10 does limit domestic law in that way. And that, in the end, Section 13, sitting as it does within the scheme of offences in Part 2, strikes the fair balance between the right of the individual to express himself and the interests of the community in being protected from terrorist organisations. So, my Lord, those are the submissions that I would make.
Very much. Mr. Porson-Pound.
Oh, thank you. I have nothing further.
Thank you. Mr. Benethan.
My ladies, my lord, purely in reply to my learned friend, with the one exception that my lady, Lady Rose, posed a question for me before lunch, which was, I hope I've understood it correctly, if we are right in our second submission, the freestanding Article 10 point, would there be a requirement for a mens rea, an intention to bring about violence? My lady, upon reflection, having discussed it with my learned friend Mr. Bunting and our instructing solicitors, and thought about it, the answer is no. And the basis for that is that the European Court of Human Rights case law, although the events that underlie the decisions either way are all actually deliberate conduct, writing of articles, going on demonstrations, etc., although it's all deliberate conduct, the proximity to violence is always the court's assessment. And thus there isn't, we do not take mens rea to that stage of our Article 10 argument. Coming then to my learned friend's various submissions, the amendment to the amendment to Section 12 of the Terrorism Act 2000 adds an offence which names a mens rea, and that amendment was simultaneous to the amendment to Section 13, which added the posting an image, etc. Well, true it is, of course, they were made at the same time, but my ladies, my lord, they were made for quite different reasons, and the explanatory notes, and can I give a page reference, electronic 612 to 613, show they were made for quite different reasons. The amendment to Section 12 was because Lady Justice Sharp, as was in the Court of Appeal in Chowdhury, pointed out that it was, my words not her ladyship's, okay to personally approve the proscribed organisation and to say so. And the legislature then introduced a clause to say, well, it may be okay, but if you are reckless in doing so, then that would be an offence. Reckless as to whether you adduce support, that would now be an offence under the amendment to Section 12. The amendment to Section 13 was to deal with online activity. Again, my shorthand, but the notes make that quite clear. So yes, there were amendments at the same time, but they weren't directed at correcting any shortfalling or any gap or any decision of an appellate court about mens rea. A broad point made in some of the authorities and by my learned friends on behalf of the respondent is that it can be very hard to prove mens rea in certain cases. Well, our answers come in three instalments, all fairly terse. Firstly, for reasons we have founded in authority this morning, we would suggest it's a poor excuse for modifying the criminal law so as to make convictions easier, that it can be hard to prove things. We would suggest that if it's hard to prove something, then there should be an acquittal, rather than prosecuting people who many would consider to be blameless. Secondly, although in theory it can be said, well, how on earth can a magistrate or a jury know what's in someone's mind? Well, the court has, I know, possibly mainly at appellate level, familiarity with the criminal system, whereby juries up and down the country and magistrates up and down the country are being invited to do exactly that every day of the working week. And thirdly, in terrorism cases, mindset evidence is now a fundamental basic of nearly every prosecution. As a matter of practical detail, the contents of an arrested person's phone is normally where it starts, and it may go to other places. But the idea that in terrorist prosecutions, mindset evidence or intentions is really something that would be new and novel, with great respect, simply is not made out. My learned friends submit that the effect of implying a mens rea into Section 13 would be to make it very similar to other sections, in particular, of course, Section 12. Well, my ladies, my lord, there is nothing new in terrorism law, at least, in having sections that overlap a great deal. Belt and braces is almost an inadequate description for these statutory schemes where terrorism is involved. There are many mechanisms, and forgive me, as this arose after, obviously, our submissions and our papers, can I simply give the court one reference if the court wants to look? It's a case called Roe, which answered the case of Zafar, which is in our bundles, had been to the Court of Appeal at least 3 times before the reports in our bundles, but at an earlier stage, a court presided over by Lord Justice Hooper had interpreted Section 57 so as to avoid it overlapping with Section 58 and made certain rulings about the nature of Section 57. A larger Court of Appeal, leaving aside fine issues of precedent perhaps, a larger Court of Appeal then overturned or distinguished the judgment of Lord Justice Hooper and said, no, in terrorism law you do get overlap. That case was Roe. The reference is 2007, Queen's Bench 974, and the paragraph to which, if the court wishes to go there at some stage, it's 34. Overlap is common in this sort of legislative terrain. Picking up, if I may, the questions from my Lord Burroughs to my learned friend Mr. Mabley. Would the reasonable observer know the protester speaks no English or is blind? My learned friend very fairly conceded, no, they might well not do. Now that does lead us fairly and squarely, we suggest, to confront the problem that without a mens rea, this section can have people who are blameless by any normal standard acquiring a terrorist conviction. I entirely take the point, I think my Lady Arden touched upon it, that there is a low sentence here, but I would reiterate the point that someone who has a conviction for Section 13, it may be to a lawyer, they would say, well, that doesn't demand actually any terrorist intent, it doesn't demand any terrorist activity. But to the great bulk of the population of bureaucrats and potential employers and immigration officials, that may be too fine a distinction. Someone who applies for jobs, applies for travel passes, whatever, with a Terrorism Act conviction on their record is seriously handicapped in the rest of their life.
I mean, it may be that even if they do not speak English or speak English well, that they recognise the symbol on the flag. So there's only going to be a subgroup, isn't there, of those who are non-English speaking.
Well, my lady, of course, makes a very fair point in the context of the facts of this particular case, but if we are addressing the mens rea argument, of course, this would be the law for all organisations and all cases, and many demonstrations do have written placards or written flags. Examples are not a particularly reliable friend, but let me go there anyway. There were massive demonstrations, for example, rightly or wrongly, I certainly don't take any editorial stance on this, about some of the Gulf Wars. There were huge demonstrations. Large numbers of people, no doubt all sorts of organisations, produced placards and banners and flags. Now, it is entirely conceivable, if not perhaps inevitable, that lots of people who were motivated to go on those demonstrations would not know the difference between the different groups, and that some of them, it's entirely possible, might not read or speak English. So it is a real problem. It is not. Of course, in any law, one can invent a fanciful hypothetical example, and when we spoke of the policeman gathering exhibits, and I think that particular hypothetical may be laid at my door, maybe that's not the best of examples, but we do say the sort of examples that my Lord Burroughs raised, my learned friend Mr. Mabley, are a real problem if the respondent were correct.
Well, are you going to come on to address some of the other points they made about prosecutorial discretion and so on?
My lady, yes. And the answer would be, firstly, the case of Gul in this court, which made the point that prosecutorial discretion is a measure of last resort and deeply unattractive, I think, is a direct quotation from this court in the case of Gul. Secondly, it is one thing, and were Mr. Mabley the DPP and Attorney General, we might not make these submissions, but it is one thing to assure an appellate court of prosecutorial discretion. It can look very different somewhere down the line. If the courts permit these prosecutions, sometimes the decisions will be those that will be not exactly offered, those suggested to appellate courts. Sometimes there won't be. And the example we can take in the case of Gul in this court, of course, the court spoke of, well, the broad definition of terrorism gets us into a difficult area because there may be groups, for example, which the British public would sympathise with, who are nonetheless armed, fighting somewhere on the planet, but reluctantly we trust in prosecutorial discretion. And yet there then were 2 or 3 investigations of British nationals who fought with the Kurds in Syria against ISIS, who were investigated, arrested, prosecuted to a very limited basis, and juries were perhaps naturally enough not very impressed. But in the end, I cannot say there has been a conviction in that circumstance. But prosecutorial discretion, as I say,
unprincipled.
They can promise you the world, but sometimes in practice down the line, if this court does not give a firm judgment, sometimes it's not quite the sure friend it might be. Turning, if I may, to the Article 10 matters, my learned friend went to one case, the case of Zana, and can I go back to the passage to which he took the court, and it's page 560, please, in the electronic bundle. It's the last tab in Volume 1. And my learned friend took the court to, page 560 indeed. He drew my lord's attention to paragraph 51 and the general principles the European Court tends to set out, in fact, in all these cases. And in particular, subparagraph Roman 3 on page 560, in exercising its supervisory jurisdiction, the court must look at the impugned interference in the light of the case as a whole, then this, including the content of the remarks held against the applicant and the context in which he made them. Now, obviously, remarks doesn't apply to our case, but we take that slightly more broadly. The content of what was done and the context in which it was done. Well, if that is the test, then how would that really apply to a mainly lawful demonstration by a group to which the British public have no particular animosity, with no suggestion of violence and no suggestion of a counter-demonstration, and no police officer, no prosecutor has ever said there is a factual basis to say this demonstration for these appellants would in any way have fueled or assisted violence. If that is the test, and if Article 10 on our second freestanding submission is an examination of the facts, how can that apply to this case, except to result in an in a violation of Article 10? And of course, the court will have appreciated long before myself, my learned friend Mr. Mabley, began to address the court, the respondent's answer to all these, and with respect, it's formulated in 3 or 4 different formulations, but the answer really is, well, it's the prevention of terrorism because the PKK is a proscribed organisation. Well, I made our submissions this morning about why we say the prescription process is an imperfect process with a very low threshold, so I won't repeat those. All I would say is this: if the court looks at the case of Gull in Strasbourg, the court looks at the case of Surek number 1, Taz and Surek number 2, those are all cases involving proscribed organisations, and they are all cases when the European Court of Human Rights found there was a violation of Article 10 for prosecuting people who took part in activities or made pronouncements in support of those organisations. So its prevention of terrorism, end of debate, line of argument, put much more elegantly by my learned friend, no doubt, simply doesn't hold water, legally speaking.
But if the evidence is that the prescription of organisations is important as part of a national strategy against terrorism, then would not the legislature be entitled to support that conclusion with a body of criminal offences which ensured that the prescribed offences do not get publicity in the UK?
Well, my lady, the short answer, with great respect, is no. The longer answer to found our legal basis for that answer is that the European Court, to an extent, is there to protect citizens against their own governments in 2 aspects, perhaps. One is the nature of legislation. Now, it's not where we are here. We don't suggest it should be incompatible. And 2 is the way in which legislation is used against citizens. And my lady, again, and it is a repetition, so I'll repeat it once then, not chance my arm as it were any further, but Gull, Surek number 1, Taz, Surek number 2, they're all cases of prescribed organisations. There was always a violation of Article 10. And really it is the European case law on which we take our stand, as it were, on our second submission. At the outset of his reply, my learned friend Mr. Mabley, Queen's Counsel, said their overarching submission was there is no need to find an imminent risk of violence. And the 2 cases he mentioned at that stage were the divisional court judgment in this case. Well, it's that we're appealing against, so of course we suggest that was not a correct judgment. And the case of Chowdhury. We've made our submissions on Chowdhury. Chowdhury was not look at the facts of Mr. Anjem Chowdhury and the other appellant. It was look at how this case should be prosecuted in a factual vacuum. So we say Chowdhury is really not a great friend to the respondent's argument. But within the various bundles, and I reassure the court I'm not going to attempt to go to any of them now unless it would help to do so. But within the various bundles, there are a series of cases, different countries, different contexts. Some are demonstrations, some are letters, some are books, some are interviews. But each and every case, nearly all of them at least, touch upon sentence. But that said, in each and every case, the court's analysis and the court's decision comes down to the proximity of violence being caused by the activity under inspection. And may I simply list them and give page numbers?
I mean what do you mean by proximity there? That people are going to be stirred up by the actual expression that is the subject matter of the prosecution. And does that have to be here? Because the definition of terrorism goes out of its way in a number of elements to make it clear that it's not just dealing with the UK, it's dealing with any government, any country, any public which is under threat.
May I deal with two parts in that
Yes.
question, if I may? Do people have to be stirred up to violence? Well, my lady, that's not the language the European Court uses, but yes, in essence, they have to be. It has to encourage, make more likely actual harm, actual violence. Does it have to be here or abroad? It doesn't just have to be here, it could be abroad. And a ready example comes to mind, which I think I touched upon this morning, but forgive me. If one looks at Islamic State, it is both a threat here, but even if there were no threat here, it would, the court may think, be legitimate to say a very large number of British Muslim volunteers, well, British volunteers, have been encouraged by Islamic State to go and fight in Kenya, in Syria, and in other countries, no doubt. So the fact that the activities of Islamic State, for example, could cause violence here, could cause violence in Syria, would not matter where it was. But my lady, the propositions we've answered in effect are in two stages. Firstly, that is the test. There has to be a danger causing of violence, and merely saying it's a proscribed organisation simply can't be the answer because of a string of Strasbourg cases where activities with or on behalf of proscribed organisations are a violation of Article 10. And secondly, if that is the test, if we apply it to the facts of this case, then that test is not met. My ladies, my lord, we have probably gone as far as we can in the large selection of cases, but the case of Gull, and I'm not going to go to them, but the case of Gull 447, the case of Zana 538, the case of Al-Akhina 1297, the case of Arslan 1377, the case of Baskaya 1405, Donaldson 1451, Erdogu 1463, Faber 1493, Gerger 1528, Karatas 1597, Maguire 1682, Surek number 1 1694, Surek and another, Surek number 2 I suppose, 1738, Taz 1787, Tazdemir 1794, Yarar 1797. Now, the court, of course, can go to them all, or in our case at page 88, I'm not going to go there, in our case at page 88, we list nearly all of them in a paragraph, summarise them. All different countries, all different contexts, but each and every case makes clear, and what we say is a startlingly consistent test. And that is the activity that engages Article 10, and there is no quarrel here nor has there been below, but that going on a demonstration does that activity increase the danger of actual violence? And if it doesn't, then it's a violation of Article 10 to criminalise that activity.
Is it not possible that all those cases are cases in which the state sought to restrict freedom of speech on the basis that it was inciting violence? I mean, the PKK is the obvious example, where the mayor speaks and it has a visible effect on the violence. And then, no doubt, the Turkish government would say, we prosecuted and imprisoned him because it incited violence. And then the European Court has to examine whether the restriction on freedom of speech was proportionate in relation to the danger presented to the state. So that's how incitement to violence, I think, comes up in many of these cases.
My lady, with respect, it is entirely. But our point is simply this. On all these occasions, the European Court applies a well-nigh identical test, which is, would what happened here lead to violence? Never mind if it's a proscribed, banned organisation, and never mind to support the Court of Appeal's decision in Chowdhury, never mind whether the words themselves in isolation call for violence, look at who is talking, where they're talking, and ask the question, does this, in effect, trigger the qualifying clauses to Article 10, which, in effect, in these cases, is always about leading to death and destruction. And if they don't, then it's a violation.
But if the offences with which we're concerned, that little group of offences, is really about preserving national security against the dangers posed by proscribed organisations here or abroad, then there's a different raft of considerations, isn't there? To establish proportionality, it's more about what you need to do to control prescribed obligations, and then there would be a margin of appreciation for the national authorities.
Well, my lady, I can do no better than refer my lady, which is quite a long answer, to all the cases I've listed already.
I shall indeed have a look.
In numerous of those organisations, there's a prescribed organisation. The recitation of the legal principles, which my learned friend has taken the court to already, speaks about a margin of appreciation. It speaks about the importance of tackling terrorism. But when the crunch comes, when the decision is finally made, in each and every one of those cases, it is our submission, the court looks at, is this going to add to real violence or is it not? And if it is not...
Well, in hate speech, obviously, that's a very considerable consideration, if it's potentially hate speech.
Yes. But, my lady, if it doesn't, we say that is a very well-established thread. And if we apply that thread, and one can apply a thread, to the facts of this case, we say there's a clear violation.
So the upshot of your submission is, if the legislation had specifically said it makes no difference or it is not a requirement that there is any incitement to violence in the conduct, your submission is we would have to read that down under the Human Rights Act in order to comply with Article 10.
Yes, if there was a specific... Sorry, forgive me.
It's a different point from your first point, because I think you would accept that Parliament could expressly have said there is no mens rea, however they put it, in this offence. But I think on this point you're saying this is not something that Parliament could have drafted its way out of. If it had included those words, we would either have to read them down or make a declaration of incompatibility.
Well, they do precisely so, because it will be a violation. If Parliament expressed it in those terms, it's probably incompatible, to be frank, or maybe a reading down, I don't know. It would depend on the motive and the grain of the legislation et al. But that's not this case. This case, because very often Section 13 would be offended by people who are encouraging violence and death and destruction, be it directly or indirectly, so we don't say it's incompatible. But in this case, we say there is simply not the evidence, and the evidence the court is aware of means this is a case where the proper solution would be to allow the appeals in the case of these three individuals and to make clear, either by a reading down or simply by the mere fact of declaring the judgment on these particular facts, to make clear that this offence should not be used in the absence of such a background. Would the court forgive my shoulder for a moment?
Yes, of course.
My lords, my ladies, unless I can try to assist any further.
Thank you, Mr. Benetham. Mr. Benetham, Mr. Mabley, we're very grateful to you for your very helpful submissions. And we're also grateful to your juniors and to those sitting behind you for the preparation of the case. Clearly, a great deal of work has gone into it, and we're very appreciative of that.
Thank you very much, my lord.
And we will now take time to consider our judgment. The court is now adjourned.